If your DUI also involves a crash, is if your client didn't have insurance, there may be issues with regard to the Safety Responsibility Act that may have nothing to do with your DUI, nothing to do with your ALS, and may have a lot more to do with the fact that he didn't have insurance. Also within driving records are any felony in Title 40, any offense committed in a commercial motor vehicle, serious traffic offenses, offenses for which points must be assessed pursuant to Code Section 40-5-57. DDS maintains all of these records according to that code section so that we can have that information available to us at suitable times, which essentially comes down to when we're making decisions about whether or not to issue a driver's license, and we're making decisions about what type of license suspension to impose when another conviction arrives. Something to think about with regard to driving records that you may or may not realize, there's verbiage in 24.317 that says a certified printout or certified anything, any certified document from DDS is self-authenticating and admissible. So that's a good way to get around trying to track down information that you may need about your client's past or about some witness's past or what have you, because that information is admissible. You don't need a records custodian. All that you need is that certified copy. Let's talk for a minute about what is a conviction in the eyes of the Department of Driver Services, because this is something that I deal with a lot with attorneys and actually with the public. The definition of conviction with regard to a driving record is a little bit different from the definition of a conviction used elsewhere in the code. You can find the definition at 40-5-1, and it is considerably more broad than most people realize. I'm going to quote it to you. A forfeiture of bail or collateral deposited to secure a defendant's appearance in court, the payment of a fine, a plea of guilty, or a finding of guilt on a traffic violation charge, whether the sentence, regardless of whether the sentence is suspended, probated, or rebated. What this means is that any first offender sentence is considered a conviction. The only exception to that is drug offenses, and there's a citation in your materials to the Priest case that talks about VGCSA. There's also a citation in your materials about Solomon versus Earp that talks about the Court of Appeals review of whether or not an adjudication of guilt is required, at least with regard to a traffic offense, for it to appear in a driving record, and the answer is it doesn't matter if you get a first offender sentence, not probably with the DUI case, but in other charges, it's important to keep that in mind. I actually have a guy that I've been dealing with for 6 years now who just cannot believe that we won't take the habitual violator conviction off of his driving record because he got a first offender sentence. And 6 years later, I talked to him again day before yesterday. The answer is still no. NOLO's a little bit different. NOLO, it varies depending upon the nature of the offense, and I'm glad you asked that. If you go through and actually look at the code sections, many of them will dictate whether or not a NOLO plea is considered a conviction. For teen drivers, a NOLO plea will not help them. For commercial drivers, at least with regard to the commercial disqualifications we're going to talk about in a little bit, a NOLO plea won't help them. NOLO will help you at least one time with a drug offense. NOLO will help you at least one time with points within 5 years. NOLO will help you one time with regard to driving without insurance or driving on suspended license. But any of your mandatory offenses, fleeing, hit and run, anything like that, NOLO is not going to help you with any of those. So go back and look at the suspension statute, go back and look at the statute that your client's charged with, and if in either of those it says that a plea of NOLO is considered a conviction, that's the way we'll treat it with regard to the driving record and with regard to imposing license suspension. Yes, sir? Right. Yes. Yes. Actually, if you've got a client, if it's misdemeanor marijuana, he actually could avoid getting a license suspension for the first 3 offenses because you could do a NOLO plea, and as long as he completes the DUI class within 120 days, he dodges the suspension, then you could do the conditional discharge language in 1613 too, and then you can do a real first offender, although by that point, are you really helping him? Because sooner or later, he's gonna get that felony drug charge, and, you know, then he's blown it, so. Yeah, so, at some point, at least with drug offenses, you can dodge the suspension bullet at least 3 times with a misdemeanor marijuana. Not so much with the felonies, but with misdemeanor marijuana, there are a lot of loopholes in there. Okay. Any other questions about what is a conviction? What about NOLA? What about first offender? Okay, let's talk a little bit about what to do if your client has something on his or her driving record that you think is erroneous. We have language in our administrative rules that says that if there is something that's on there that's wrong, we will correct it, but we need documentary evidence to support your contention that it's wrong. Usually that needs to come from the court from which whatever the mystery information came from. They could have sent it in about the wrong person. They could have forgotten that they agreed to reduce the speed on the speeding ticket. They could have forgotten that you client pled to the less safe rather than a per se, and have sent us the blood alcohol results, which may be creating some problems. So generally, we need that documentation from the court, particularly if you're dealing with the folks in the Licensing and Records Division who are, for some reason, suspicious of those attorneys. I'm less so for, I don't know what reason, but they're going to want to see it from the court, either a certified copy, they'll accept a fax directly from the court. I'm a little bit more liberal, actually I'm a lot more liberal with regard to that. If you fax it to me, I'll take it to them and convince them that you're not trying to trick them. But that's really the exception, not the rule. Don't be surprised if you try and fax something to the Licensing and Records Division and they say, that's fine, now I'll get the court to fax it to me. Rather than that, just fax it to me and my contact information is at the end. With regard to the court's ability to change its mind, let's say it's not a correction per se, but you and the court decide you want to change what the disposition was of the offense. At least with regard to traffic offenses, you need to remember the verbiage in 40-1332 and 40-1333, because there are statutory limitations on the court's subject matter jurisdiction with regard to those tickets. From day 1 to day 89, the court can do anything it wants to. It can go back and vacate the conviction. It can go back and change that vehicular homicide to a speeding ticket. It can do anything it wants to. Day 90 through 179, there are statutory procedural hoops that you're going to have to jump through. Not insurmountable, a little bit annoying, but certainly doable to get the court to make those changes. We're going to be looking for the documentation of that if you're on day 100 or 115 or 120 after your client's case was disposed of. And if the court sends us an order without at least mentioning that it complied with 40-1332, we're going to be telling you and or the court that we need to see that verbiage. When we get to day 181 and after, we're going to politely tell the court that we understand that the court has changed its mind, but on the advice of the Attorney General's office, we are not going to be able to change the driving record with regard to whatever new disposition the court has entered. Now, the magic language to use there is if the court goes back and says, no, what I sent you the first time was an error, we're not going to delve into whether the court's telling the truth or not. So that's something to remember for day 185, day 300, what have you. If the court tells us that what they sent us originally was erroneous, we're going to believe them. But if the court's not willing to do that and they really want to go back and change it, you need to be very mindful of those time frames, or it's not going to do any good, at least with regard to the driving record. All right, any questions about getting stuff onto and off of driving records? Now let's talk a little bit about who has access to driving records. Driving records are exempt from disclosure under the Open Records Act. And for those of you who have caseloads that include things other than just pure ALS and DUI cases, this is going to be particularly important for you if you ever want to get somebody else's driving record. It may even be relevant in your DUI case if you're trying to prove that somebody else is driving. These records are not accessible to the public. and we cannot give them to anyone except for the recipients that are enumerated in Code Section 40-5-2. Insurers, employers of commercial drivers, judges and prosecutors and law enforcement, the DMVs in other states, school systems can have them for their bus drivers, rental car companies can have them. Creditors can get your address, but nothing else. We will release them pursuant to a subpoena. Don't send us a request for production of documents. The statute says subpoena. The AG's office makes us read that literally. So you will get a polite, very, very canned letter back from us, maybe even from me, saying, thank you for your request for production of documents. Now send me a subpoena because I can't respond to this. Governmental entities can have access to driving records. We make them available to law enforcement through GCIC. Selective Service has some limited access. Department of Defense, those are related to also to recruitment efforts. Secretary of State's office has access for motor. Jury commissioners for putting together the jury box. Department of Human Resources has limited access because of child support enforcement efforts. Police and fire departments can have access to run background checks on their employees and their applicants for employment. And finally, organ procurement organizations. So those are the folks who can have it without sending us the subpoena. The only other option that you have is to send us the written consent of the licensee, which, particularly if you're dealing with a civil case and it's the opposing party, yeah, good luck getting that. We maintain records of every time we release a driving record. Curiously, this actually has come up this very week. We actually have a situation with a civil attorney where the fact that this guy's employer got his driving record is going to help them prove the employer's negligence. So that's something to be mindful of, is that we have records of every time we've given out a driving record for the past 4 years. Okay, that's driving records in, driving records out. Any questions about that before we start talking about when we take away driver's licenses? Okay. First thing I want to talk about is differentiating among the different types of withdrawals. Everybody pretty much uses suspension as kind of the generic term, but suspension is actually a term of art. It's defined in 40-5-1, and the definition is a temporary withdrawal by formal action of the department of a person's license or privilege to operate a motor vehicle on the public highway, which temporary withdrawal shall be for a period specifically designated by the department. Basically, that means we're taking away your driver's license because you've done something bad. A revocation is a much more serious situation. It is the complete withdrawal of the driving privilege. Anyone who has their license revoked, the two main situations where that would occur would be a habitual violator or someone who is medically incapable of driving. Those people, when they're ready to start driving again, have to start from scratch. They have to come back in and retake the written test. They have to come back in and take the road test again. So in addition to whatever reinstatements or requirements there are imposed by the statute, there are those additional burdens of making sure that your client actually does know what the different signs say and what the different signs mean. Third type of withdrawal I want to talk about is a cancellation, which you may have seen some of, particularly in the last few years, related to Social Security numbers. This is essentially a situation that occurs either when we've been given mistaken or fraudulent information, or when a customer fails to provide information that's required, or if we discover that a customer was not eligible for some driving privilege that we gave them. An example of that would be if someone were to come in and get their Georgia driver's license, and at the time we didn't realize that driver had a suspension in another jurisdiction. There's verbiage in 40-5-22 that says that if you're suspended, revoked, or canceled in another jurisdiction, you cannot have a Georgia driver's license. So if that person had a license and we subsequently discovered that we shouldn't have given it to them, we would have canceled that license. The next 6 pages of the written material are something that I kind of run around with a lot. It is just a relatively high-level cheat sheet of all the different types of license withdrawals. The first section talks about suspensions resulting from convictions. And this section is information that's going to be particularly important with the enactment by the General Assembly of House Bill 1111. You may have seen the Court of Appeals decision in the Fuller case back in January that talks about notice for driving on suspended license. And although the General Assembly had taken out a lot of the notice language, particularly with regard to failure to appear suspension, the Court of Appeals didn't like that in the Fuller case. They made that really clear. So what will be happening with House Bill 1111 starting January the 1st is it will be explicit in 40-5-60 that any suspension that occurs as a result of a conviction, actually it's in suspension or revocation, that occurs as a result of a conviction, the driver will have notice of that by operation of law. So what we had tried to accomplish 3 years ago is actually going to come more fully to fruition, at least with regard to these. So these next few pages, you need to be very mindful of the fact that if your client is charged with driving on suspended license and that underlying suspension is based upon any of these, definitely where it's not clear in the statutes now, it will be extremely clear come January that that person has notice by operation of law, and you need not bother the prosecutor or the arresting officer with where is the proof of service, because there won't be any, because there won't be any needed. The next page talks about withdrawals of commercial driving privileges, and I'm going to talk about that some more in a little bit. But the withdrawals with regard to CDLs are based upon verbiage in federal law, particularly the regulations promulgated by the Federal Motor Carrier Safety Administration, and they are positively draconian. And if you have a client who is a commercial driver, you need to make yourself very, very aware of the potential consequences, because that ALS and that DUI are nothing compared to what's going to happen to that CDL. The next section is about withdrawals predicated, but not predicated on convictions. It talks about court-ordered suspensions, teen drivers who have their licenses suspended for school misconduct or school absences or withdrawing from school. There are cancellations that I talked about earlier are based in 40-5-50. There's suspensions for failure to pay child support. We're going to go back to sending those notices by certified mail beginning in January. Also for failure to appear, the same thing as a result of the Fuller decision. We will resume sending notification of those suspensions by certified mail in January. We talked earlier about the medical revocations. Those are imposed pursuant to either 40-5-59 or 40-5-35. ALS we talked about a good bit today, and then we've already touched briefly on safety responsibility. Any questions? I know that's a lot of material to assimilate. Yes, please. Here's the thing about that. It's already gone. Back when the code sections were changed to implement the electronic insurance compliance system, the verbiage in the limited driving permit statute that allowed for a permit for a child support suspension was deleted, and the only place it appears now is in 54.1, and it references you to another code section. Only that code section doesn't have anything to do with permits anymore, so there has not been any permit eligibility for a child support suspension for about 3 or 4 years, maybe even 5 by now. Long time. So it's, you could apply, but you would get turned down every time because there's no enabling language in that other code section that 54.1 points you to. That's actually, the language you're talking about is actually in, I think it's in House Bill 1111 to be deleted after January. But the permits are already gone. It's just, that's really more clean-up language. Okay. If your client is not a resident of the state of Georgia, it's important to remember that the penalties that are imposed on a Georgia resident also get imposed on the non-resident driving privilege of your client, which means that we'll impose a suspension and we'll mail the ticket home to wherever he or she is from, and they'll probably impose a suspension too. So that's something else to be mindful of, is if you're representing a client who got in trouble here but is licensed somewhere else, it will be in your best interest and their best interest to find out what the license penalties are going to be in that jurisdiction as well, because as much information as you give them about your knowledge about how the Georgia process works, not knowing what's going to happen in that other jurisdiction may make them much madder than anything you could have done here. Also important to remember that a Georgia resident is held accountable for their conduct outside the state of Georgia, just as if the case had been adjudicated by a Georgia court. So if you have a client who went to Nebraska and got a DUI, we're going to treat it just as if it was a DUI in Georgia. If you have a situation, yes, ma'am, I'm sorry.
They have reporting requirements.
All but 6 states would, the compact, exactly. All but 6 states are members of the compact, and really the compact language is less of an issue now because of all of the federal mandates to exchange information for commercial driving privileges with the Motor Carrier Safety Improvement Act from the Fed. There's 6. I might be able to get y'all 6. California, Michigan, I want to say Wisconsin. There's a, if you go
Hawaii is one, isn't it?
I don't know about Hawaii. If you want to look at, there's a map that shows the states with the different compacts that they're a member of. If you go to www.AAMVA, which is AAMVA.org, and in their search thing, type in compact, they have a 3 or 4 color map that shows you which states are members of which of the compacts. I'm sorry, I knew 3 of them.
Well, also mention which compact you're talking about right now, because
There are 3, at least.
Okay.
It's above a mention for me to mention which is the compact. There are at least 3 compacts that the states are participating in. There's the non-resident violator compact, which Georgia is a member of, and those 6 states are not. There's the driver's license compact, which Georgia is not a member of, but it doesn't really impact our ability to send anything anywhere. Then there's a new compact that's referred to as the DLA, the Driver Licensing Agreement or something like that, that only about 4 or 5 states have signed, and that's kind of the direction that our association, AMVA, is trying to push the states, but they haven't got a lot of traction with that. So if you take a look at that information on AMVA's website, it'll show you that map, and then you can do some more research about the different compacts and the different impacts that they have as far as your client, the state that your client is either in trouble in or from. Okay. If you find yourself in a situation where you think that the information on your client's driving record is correct, but you think that the penalty that's been imposed, at least as far as the license suspension or revocation, is wrong, there are 2 different tracks that those appeals follow, administrative tracks, not talking about going to Superior Court. Some cases, and it's actually, the 2 tracks are actually dictated by language in the Administrative Procedures Act. One track goes to OSA, the other track is all reviewed internally at DDS. Anything that is a suspension that occurs as a result of a conviction, essentially where there aren't really any fact questions, either if he was convicted of it or if he wasn't, those are all handled internally by DDS. It's all hearing officers that have been appointed by the commissioner. We're all either lawyers or paralegals, and we try and get those responses out within about 60 days. The things that go to OSA for appeals, in addition to administrative license suspension, would be the teen drivers who are suspended for school misconduct or school absences or school withdrawal, failure to appear, medical revocation. I think what else? If we deny a limited driving permit or we revoke a limited driving permit, if we deny a habitual violator's probationary license or revoke a habitual violator's probationary license, those cases are going to go to OSA. Everything else is going to be heard by one of the in-house hearing officers. And when I say heard, it's not the sort of thing where you're going to come to Conyers and actually present testimony or anything like that. It is a documentary review of what's on the driving record compared against the information that you've provided in your appeal. And if a decision can be made based upon that documentary review, and it basically always can be because there's suspension by operation of law. So there's either a conviction or there's not, and we've either imposed the right suspension or we haven't. Honestly, I think I've only ever taken testimony once or twice, and it was really more just so that the guy could have his say, and he knew walking in the door that there wasn't anything we could do. He just kind of felt like he had to get it off his chest. So the case that talks about that procedure is Miles versus Shaw. The citations in your materials on page 15. Please remember that the only suspensions that are stayed by your filing of an appeal are administrative license suspensions arising from DUI arrest. So don't think that your client's going to be able to keep driving if you appeal the habitual violator revocation or something like that. It is not stayed while that appeal is pending. It is in effect while that appeal is pending. And if your client gets stopped while driving, if the officer runs the status through GCIC, it's going to come back suspended, revoked, canceled, what have you. So it's important to remember, unlike administrative license suspension hearings, your client has no driving privilege while those appeals are pending. I want to turn now and talk about, I'm sorry, I did the second time, safety responsibility suspensions, the ones that are not based on judgment, the ones that are before the case goes to civil court, those would also be stayed. I apologize for not mentioning those. Let's talk about some things that you may need help with as far as helping clients out with situations where the record is almost right, for lack of a better description. An example of this would be getting the administrative license suspension deleted when the DUI case is reduced or dismissed. And hopefully everybody knows that if you win the ALS case, obviously it will be taken off the driving record. But if you win the DUI case, after you lose the ALS case, we still are required by law to take it off. So it's important to remember that if you get it fled down to a rec list or something like that, you need to make sure that that information is conveyed to DDS and check on it. I mean, the courts have to report that information to us statutorily, but just because it gets reported doesn't mean that necessarily we're going to be able to identify that the rec list ticket that just arrived matches up with that administrative suspension on your client's driving record. The most typical cause for this is because the case numbers are different. The ALS will come in with either the officer's case number for his report, and then the rec list will come in with the citation number, or the 1205 will come in with the citation number, and the rec list ticket will come in with like an accusation number. The system's not sophisticated enough to figure out, hey, this might be the same case. It's just looking to see if it's exactly the same, and when it's not exactly the same, we need to have a little manual intervention. So if you have a situation where your client reckless driving conviction is showing up on his driving record and the ALS has not, the companion ALS has not gotten deleted, get in touch with us and we'll get that corrected. It's usually just a case number problem, or every once in a while there'll be some sort of typographical error with the incident date, and it'll have the same case number but not the same incident date, and because of that, I mean, we all know that a guy can get a DUI today, a DUI tomorrow, or 2 DUIs today if you really put your mind to it. So that's something where it's just a matter of it not matching completely. The system's not going to recognize it. Also, occasionally we have problems where the customer will not get credit for the administrative license suspension towards satisfaction of the suspension that results from the DUI conviction. Again, this is usually just a situation where the system can't match the two up excuse me, because they don't appear to be identical.
Some water with it. Sure.
Usually that, again, is also a case number disparity, and it's pretty easily remedied. Now, you need to remember the exact language from that code section, 67.2b. Your client gets credit for the ALS towards the DUI suspension. It does not work the other way around. If you get the criminal case resolved first, he does not get credit for the time served on the DUI suspension. So let's say he gets arrested tonight and he's very, very guilty, and you plead the case out Monday morning when it's before the judge. Not very likely to happen, but it could happen. And the ALS doesn't go to a hearing until sometime in June. All that time that your client's serving on that suspension resulting from the DUI conviction does not get credited toward the administrative license suspension. So that's very important to remember. It only works if the ALS goes into place first. Everybody clear on that? It's also important to remember that there's no credit for the ALS towards habitual violator revocation. Yes. If the criminal conviction is entered and the suspension resulting from the conviction goes first, you are not going to get credit towards the administrative suspension, be it per se or a refusal. And there is no credit for the administrative suspension, no matter what it is, towards the habitual violator revocation. Do what now? Under 21, you will get credit as long as it's the same thing. If the ALS starts first, you will get credit towards the suspension under 57.1, but not if it's the other way around. Okay, let's talk about limited driving permits. I seem to get a lot of questions about this, and there's a lot of misconceptions about the availability of limited driving permits and the uses of limited driving permits and what happens if you misbehave once you've got a limited driving permit. The statute 40-5-64 is very specific. It actually uses the expression when and only when, which means that we can only give your client a limited driving permit when and only when the suspension that he or she has is one of those enumerated in 64A1. That means that there are no permits for refusals, because the code section for refusals is not listed in 64A1. There are no permits for a second in 5 DUI until you get to that ignition interlock permit. There are no permits for a second mandatory suspension. So if your client had a prior conviction for fleeing, he gets a DUI tonight, there's not going to be a permit. There's going to be that 120-day hard suspension before he or she is eligible for reinstatement. So before you call me, ask me if your client is eligible for a permit. Take a look at 64 and think about what code section, particularly what paragraph or subparagraph is the basis of your client's, Bubba has pulled up the AMBA website. The non-members of the driver's license compact are Montana, Oregon, California, and Alaska. Although I thought there were more than that. Okay, and then Michigan and Wisconsin are not members of either. So those are the 6. Michigan, Wisconsin, Montana, Oregon, California, and Alaska. That was the one.
I was thinking of what that.
Yes. But it's color. It's easy to read. Okay, so please think about that, about the permit. Take a look at the code section that applies to your client's license suspension. Permits are only usable for a very limited scope of activity, and it's really important to make sure that your client understands that. He can go to or from his place of employment or perform the normal duties of the occupation, go to receiving scheduled medical care or obtaining prescription drugs, going to a college or school where he's regularly enrolled as a student, attending regularly scheduled sessions of support organizations for addiction or substance abuse or other similar type treatment, and any court-ordered driver education or improvement school or alcohol or drug program approved by the court. It's important for your clients to understand that they cannot drop their kids off at daycare on the way to work. That's not a permissible use of the permit. They cannot go to the grocery store on their way home from work. That's not a permissible use of the permit. If it's not enumerated on the permit, and really there's not going to be anything that's not in this code section that's going to be on the permit. They can't take side trips. They can't drive themselves to lunch on the permit. They can't go out to a movie on the permit. They can go to work, they can go from work. If they're a plumber and they need to go to people's houses to fix pipes, they can do that. But they can't make pit stops along the way. They can't drive to their probation officer. It's very, very limited.
How about take their kids by school on the way?
They can't take their kids to school on their way anywhere like that. It's all very strictly set out by the General Assembly what is and is not permissible. And while it may or may not make sense, it's what the statute says, and we have no authority to exceed or change that. Can't go to the probation officer. No.
That's why they arrest you when you drive up.
If you think about it, you can't even go to court on your permit. So it's really important to emphasize with your client what is and is not permissible. It's also important for them to understand what happens if they are eligible to get a permit and get a ticket afterwards. Any moving violation will result in a revocation of permit. Lots of people, I cannot tell you how many hearings I've been to at OSA where we get in front of the ALJ and the customer says, I didn't know that this new ticket was going to result in a revocation of my permit. And then I pull out a copy of the permit application where it says in very clear letters, if you get another ticket, we're going to take away your permit. It's really important for people to understand that at any moving violation, seatbelt counts. Seatbelt violation counts. If you're driving and you get a ticket, your permit is going to go away. Yes, Alex?
it's a new ticket, any ticket, we get a ticket before we get our permit.
No, that would not. It has to be a permit, it has to be a ticket issued after the permit was issued and adjudicated before the permit expires. We have had some issues in the past programmatically as far as the computer picking up tickets that were issued before the permit was issued and picking up tickets that were issued or were adjudicated after the permit expired. If you find a situation like that, get in touch with me because we'll get that deleted because it's just a glitch that I think we actually finally have fixed. But it should only be a permit revocation if it was, the ticket was issued after the permit was issued and the ticket was adjudicated. And by adjudicated, I don't necessarily mean an actual adjudication. The case was just resolved, because remember we talked about FOP. The case was resolved before the permit expired. Very, very important, if your client gets a new speeding ticket while they're driving on that permit, beg the new court to wait and dispose of the new speeding ticket after he reinstates his license. There won't be any consequences from that. We're not going to revoke a permit that doesn't exist anymore. But I can't tell you how many times the customer was eligible to reinstate the license, just didn't get around to it for whatever reason, got the new ticket, got convicted, went in and got reinstated, and we still have to impose that additional 6-month suspension. Because that's the consequence when you get the new ticket. Not only does the permit go away, but it extends the suspension for 6 additional months. That's paragraph G of 40-5-64. So it's very important for your clients to understand the permit is the hardship exception, and I find myself in front of the ALJs having to, they beg for a hardship exception, that they have to drive to work and what have you. They've had their opportunity for the hardship exception in actually getting the permit. And there's not a hardship on top of the hardship. Arguably, or should there be? Yes?
Are you saying that a permittee on the way to work can't pull off the highway and fill up with gas and empty his bladder?
That would fall into the discretion of the officer that he or she were to encounter. Let's say he backs into somebody in the parking lot at that convenience store. I would be willing to bet that the officer would charge him with driving in violation of the permit.
What do you say about it?
I say that it's not any of my business, and if he gets convicted of it, then I'm going to take away his permit.
And if he doesn't go to the bathroom before the officer puts him in the car, he can pee in the car.
Yeah. Yes, sir.
What's he ever waiting being cut?
It is a moving violation. The vehicle has to be moving for you to have a seatbelt violation. We've actually litigated this with OSA. It will result in a permit violation. Go back and look at 64 paragraph G at that verbiage, and then go read the seatbelt statute. The vehicle has to be moving to have that seatbelt violation, so it's considered one of the offenses that will, one of the offenses that will result in a permit revocation.
And follow-up to your question, you say that any moving violation of chapter 6, a lot of times, speeding tickets, someone's charged with a permit. I mean, if the speeding ticket, let's say it's reduced to non-reportable speed, presumably no one can get notice of it, is that correct?
That's a great point. If you can convince the court to reduce it to 14 or less, we would never get it if we'd never know. Too fast for conditions is another one where we would never know.
Proper search car, properly search park vehicle.
I'd have to go back and actually look at the regulation to tell you. If you look at our website, we actually have a regulation on there that lists all of the offenses that are in that catch-all under 40-5-57 and all other offenses get 3 points. Take a look at that, because there's like 60 or 100 of them on there. I can't remember them all.
Follow up what this gentleman was saying about that, about 4876.1 about seatbelt. Now, is seatbelt being reported to the officers? Typically, the various state courts only report the moving violation, so a lot of times.
Seatbelt is reportable. It's actually in the statute, but it is reportable. Yes, sir.
Talking about that, moving violation, talking about speeding violations is different in a different section, so you normally know one moving violation every 5 years, you know a speeding charge, and
anything that's point bearing, you get one NOLO every 5 years.
So if you use it on a team,
That's it for your 5 years. Yes, ma'am.
You may not be able to, have there, to your knowledge, has there been any legislative discussion about, the exception of a parent or any people who take their children and whether obviously getting their children to doctor to school or things like that?
I am not aware of any of those discussions having taken place. To be honest with you, the legislature doesn't get real sympathetic about people who have these kinds of situations because they've gotten themselves into some kind of mess. Is the way that they view them. You know, it's supposed to be punitive. The license suspension is part of the consequences of whatever the underlying offense was. Although it's not a criminal penalty, no double jeopardy.
It just seems weird to start affecting the children.
Oh, sure.
I was just wondering if there.
I think that usually when those discussions start, they usually dissolve into, well, they should have thought about that before they got whatever the offense was that resulted in the license suspension, and it usually kind of dissolves completely after that. Yes?
what's the current status of electronic reporting? Is that pretty much in place statewide now?
Yes and no. There are about 1,500 courts that have the ability statewide to hear traffic offenses. The majority of tickets are reported electronically. I don't think I could say that the majority of courts are reporting electronically. So that the big courts that do most of the work are reporting electronically in a pretty timely fashion. We do have the occasional glitch, like if any of you are from the LaGrange area, Truth County Probate Court discovered recently that they had a problem with their software and that their tickets weren't coming in. They were sending them, they thought, but they weren't making it to people's driving records, and so they sent us about 2 years worth of tickets all at once. That's been fun. Yes, sir.
Okay, kind of a technical question. I'm coming from the prosecution side. I've had defense attorneys ask me on the refusal case, on null process, refile it.
You don't-
Our clerk said it won't work.
It won't work. I love the creativity. It won't work. We always catch them. I love the creativity, but we'll catch them. The question deals with trying to get the refusal off the driving record by having the DUI ticket null proc and then refiling it. When it comes back in, we catch those. But again, I love the creativity. Okay. Yes. They will have a suspension. The question is about the 120-day window if you enter a NOLO plea to misdemeanor marijuana. If your client completes the class on day 121, we will accept that as part of the requirements for reinstatement. They also need to bring us $210. They're not going to get a suspension. They have to, the statute says that they have to complete the class and provide us with evidence of that within 120 days. Yeah, sorry. Yeah, day 121, the answer is no, I'm sorry. Now, let's say he takes it on day 120 and we get it on day 121, that I can probably make work. Technically, I probably shouldn't, because it says they have to have it to us in 120 days, but, I mean, that's kind of ridiculous. So, anyway, just get me.
Based on failure to pay child support, we went to trial and showed that the revocation was issued in error because the child support was paid. And showed that back then, we had question ability to work, especially the insurance company. So they were reporting on so many of the payments that were being made. Did y'all do any follow-up with that?
No, we actually don't have any authority to do anything but impose the suspension when DHR tells us that it needs to be imposed, and lift it when DHR tells us that the person is complying with their child support again.
In other words, if we go to trial and show that the DHR has get a court to issue an order to have it issued?
Sure. Oh, sure, yes. If a court says that the suspension was an error, I'm not sure that the court in the criminal case would technically have standing to issue an order to lift the suspension, but if you're in a situation where you think your client's suspension was, the child support suspension was imposed in error, if you can get me the documentation of that, and I can verify it with the HR, I'll make sure it gets off there. Doesn't happen, I have not seen very many of those at all, maybe like a handful in the last 7 years, seriously. Yes, ma'am, back. No, actually, and I had to write this way before the legislative session was over, but we can talk about Senate Bill 350. The way that I read Senate Bill 350, I think it does not have that language like House Bill 336 has. And if your client has 3 prior convictions for driving without a license, if he gets one July the 1st, it's going to be a felony and it's going to go to Superior Court. Now, here's the good news about that, and I have some bad news to come after that. The good news about that is DDS does not, at this moment, collect convictions for driving without a license. So the only way your client is going to get charged with a felony driving without a license is if basically the jurisdiction he's in can figure out themselves that they've charged him 3 times in the past. It's not on GCIC, it's not on our driving record. So the local court may say, hey, this guy's been here 3 times for this before, we need to bind this over to Superior Court. But if he's been driving without a license all over the place, it's going to probably be a year or more before you start seeing people charged with a felony violation of 40-5-20. And here's the bad news. Senate Bill 350 also makes it a felony to drive on a suspended license for the 4th lifetime offense. So those folks are going to start seeing felony charges starting January the 1st. Because those are on TCIC, those people have been fingerprinted every time they've gotten charged, and it is going to show up on a driving record. So that information is going to be very easily available to prosecutors and to law enforcement. Yes, July 1st.
July 1st, you said January 1st.
I'm sorry.
That's okay, that's all right, I just want to make sure they
July,
know.
It's July.
It could
yes.
be January 2nd and they could be gone.
Yes, it's July, Senate Bill 350 is July 1st, and there is no look back like there is in House Bill 336. Right. Fourth time suspended license. And the way that I read Senate Bill 350, you can't mix and match, like, here are 2 driving without a license and 2 driving on suspended license. That's the way I read it. I mean, you may end up, probably some of you will end up litigating that issue with prosecutors, and the prosecutors in the room may litigating the rest of you. I don't read Senate Bill 350 as saying you can mix and match a couple of 40-5-20 with a couple of 40-5-21, but I could be wrong about that.
5 more minutes.
Yes, sir. That's a really good question. We have not given any thought to that at the moment. Here's the flip side of that equation. I actually have the ability at headquarters to get a driving record all the way back to the first time that person was licensed, or the first time he got a ticket and he got a ticket before he got licensed. In the customer service centers, the functionality that they have is limited to the 3-year or the 7-year. If you need more than that, if you'll get in touch with me, I can get you more than that. But that's not something that if you just want to go to a local center, particularly those of you who are out middle and South Georgia, that's not available just walking in the door of a customer service center. Okay. Want to talk just real quickly, because I've only got 5 minutes, so I'm going to have to cover like 12 pages in 5 minutes, no problem. Permit eligibility for multiple offenses. Please take a look at Dozier versus Jackson from 2006. If your client has DUI and endangering a child by DUI, that's considered 2 separate convictions for purposes of imposing a license suspension. So that client with, even if it's just those two charges from that one incident, they're gonna be looking at a hard year suspension followed by ignition interlock device requirement. So take a look at Dozier versus Jackson citations in here. And this is actually one of those appeals that went through the internal process, and I was affirmed by the Court of Appeals, which is kind of cool. Ignition interlock requirements, there was language that went into effect a couple of years ago that talks about permit revocation with regard to ignition interlock permits. The ignition interlock providers are supposed to be reporting to us when customers don't go in to be monitored or if they tamper with those machines. We haven't seen a lot of compliance with that for some reason. I think it may have been due to the fact that we had no regulatory authority over them to make them do that until about a year ago. So I have actually started seeing these show up. So you probably will start seeing them show up in your offices to folks who have license or ignition interlock permit revocations due to their failure to go in and get the machine monitored. Remember that ignition interlock does not apply to a non-resident, but moving out of state after you're convicted does not make you a non-resident. The time that you look at is when you got convicted. If you lived here then, you're in trouble now. Please be aware that the only exception to the ignition interlock requirement, at least with regard to a resident, is the financial hardship language. I spoke to the state court judges last week, and they're real mad at me because we've been telling people that if they want to try and ask the judge to go back and grant them the financial hardship even way after the court case is over, they will accept those even way after the court case is over, notwithstanding the language of 401333. They're not real happy with me. Well, some of them are not real happy with me about that. Others think it's great because they want to help people with those issues. But that's the magic language we're looking for in those orders, financial hardship. If it does not say financial hardship, your client will be getting ignition interlock device. Take a look at 40-5-61, paragraph E, if you have questions about the calculation of your client's eligibility for reinstatement. Please remember that the day that a suspension starts is not necessarily the day that we start calculating that eligibility for reinstatement. That sounds like I'm splitting hairs, but there is actually a statutory distinction. So if you have a question about that, take a look at paragraph E of 40-5-61. Charlie had talked about convincing the officer to withdraw the ALS in exchange for a guilty plea. Please be mindful of the time limitations on that. The regulations of DDS provide that if the customer does not request a hearing, then the officer's opportunity to withdraw the 1205 dies after that 10th business day. Similarly, if the administrative law judge has issued the final decision, the officer's ability to withdraw that 1205 is gone. So please be mindful of the timing of when you work out those deals because it does matter.
Mention what happens if the person doesn't get the 1205 and you only learn about it after the 10 days.
Okay. If you have a situation, Charlie was talking about how vigilant he is about getting documentation of the fact that he has sent in his letter and the fact that he sends letters even if the client does not show up with the 1205 form. If you have a situation where your client did not get served with the 1205 form and subsequently finds out about it, if you can document that to me, we have language in our regulations that will allow us to waive the 10 business days. Now that doesn't mean he realizes in February that there's an administrative license suspension and then I get a letter in May, which is something that happened last week. I had to write back to that lawyer and say, I could give you 10 business days from when you figured it out in February, but 3 months is probably not really realistic. I hate that we're not going to get a chance to talk about commercial drivers, but here's the most important thing. If you have a client who is a commercial driver, commercial truck driver, a DUI conviction will result in a mandatory suspension of that person's driver's license for 1 year. There is no permit that will allow them to drive a truck. Same thing is true for a refusal or for a per se administrative suspension. It will result in a 1 year disqualification for which there is no permit. A second conviction or a second refusal or a second per se administrative suspension or any combination of those will result in a lifetime disqualification from driving a truck. This is very, very important information for y'all if you have a client who is a commercial truck driver. You really need to familiarize yourself with the language in 40-5-151 and on the federal side 49 CFR 383.51. It is all about draconian. They will take it away and they will not give it back.
You don't have to be, you don't have to be in a commercial vehicle either
You
time.
do not have to be, I'm glad you mentioned that. You do not have to be in a commercial vehicle if you are the holder of a CDL. And a lot of the penalties that apply to commercial drivers apply in Georgia at least, even if you've never held a CDL. We will proactively prohibit you from ever getting a CDL. So it's really important if you have a client who's thinking about becoming a truck driver, to be aware of that. Want to talk for a second
Got
about
one
teen
question.
drivers?
One question.
I just, is this not, you're not eligible for early reinstatement of your CDL, can you get early reinstatement of a license without a CDL?
Yes, you can get your Class C license back or get a permit to drive a passenger vehicle, just no truck driving. Teen drivers, take a look at 40-5-57.1. I'm sure y'all are already very familiar with that. Something to remember about that though, when you're working out that deal to plead to reckless instead of DUI, if your client's under 21, that's not going to help him at all. In fact, it may actually be a problem for him because of the way that the credit is given. You agree to plead to reckless because you know that's going to make the administrative suspension go away, but your client who's under 21 is still going to have a driver's license suspension, and we're going to have to delete the administrative suspension, so there's nothing to give them credit for. So they start from the date of conviction or later, depending on 61 paragraph E. So with teen drivers, if it's someone who you think is not going to reoffend, which I know is a gamble to go out on that limb, but you may actually not be doing them a favor by getting rid of the DUI. They may actually, in the short run, be better off with the DUI conviction.
And if it's a second reckless for a CDL, there's a suspension there.
Important to take a look at the serious violations in 40-5-151. 2 convictions for reckless driving, as Doug said, are a 60-day disqualification, and 3 of those within 3 years is a 120-day disqualification.
For CDL.
For commercial drivers. The stuff that is in the end talks about what's going on with Social Security number cancellations. I think we've pretty much beat that horse to death. Pretty much every customer has had their Social Security number checked, so we're in good shape there. Real ID Act. Georgia has not decided to be Real ID compliant yet. We are positioning ourselves to be Real ID compliant if the General Assembly and the governor decides they want us to be Real ID compliant, but that hasn't happened yet. One of the things to remember about that is if you have customers or clients who are non-citizens, when they're coming in to apply for a license or a limited driving permit, we're going to be checking their immigration documentation every time. The validity of their permits and licenses is tied to the expiration date on their immigration documents, and we have to be able to electronically verify their immigration documents through DHS's SAVE program. The very last page is contact information for me, both phone and fax. Also, some phone numbers to call if you have other issues about other things. And I know that you've already talked this morning, apparently, about House Bill 336, and I'm guessing that you've talked about your source code.
Well, we laid off the source code.
Okay, well.
This is more of an update.
There was a recent development, I'll just say that. And there was a decision, it was either early this year or late last year that I don't know if Alan Trapp is here, but his brilliant approach to trying to attack administrative license suspension and a DUI for a commercial driver by saying that the fact that the implied consent card didn't warn them about the commercial disqualifications, the Court of Appeals said no to that. So, that's it. All right, I'm done.
Take the bottle of water.
Thank you.
Thank you.